Now, investigating Directorate Against Corruption, or IDAC's head, Advocate Andrea Johnson, faced intense questioning at the Madlanga Commission yesterday. The Commission has criticised Advocate Johnson for applying the wrong legal test when assessing a Section 27 referral. Now, the referral ultimately led to the investigation of Crime Intelligence Head, Lieutenant-General Dumisani Khumalo and 6 others. The Commission's Chairperson, Justice Mbuyiseli Madlanga, also criticised Johnson after she conceded that she had mistakenly assessed the referral using a subjective test instead of the objective test required by law. So to weigh in on Advocate Andrea Johnson's testimony yesterday, we're joined now by Senior Lecturer at the Wits School of Law, Dr. Shadi Maganoe. Dr. Maganoe, thanks so much for your time. Welcome to Morning Live.
Thank you for having me.
So from a legal perspective, first and foremost, how have you assessed Advocate Andrea Johnson's appearance before the Commission so far?
I think based on yesterday's evidence, just apart from the way she answered the questions, I think yesterday's evidence shifted from the inquiry of just an individual or individual conduct to institutional accountability, because remember, this is the head of an anti-corruption institution. So I think the Commission wasn't simply asking whether Advocate Johnson made the correct decisions, but it was asking whether IDAC exercised its statutory powers lawfully from the very beginning, because she was the one who was supposed to ensure that IDAC uses its public powers within the remits of the law. So the Section 27 referral became the focal point because it is the legal mechanism that triggers IDAC's investigative jurisdiction. So the Commission now wasn't just, it was asking whether IDAC merely received a complaint or whether it played a role in creating that complaint that ultimately gave it the jurisdiction to investigate. So I think that distinction is very important, because investigative institutions must be independent and they must also exercise powers only conferred to them by law. So I think based on the evidence that she was giving yesterday, it basically shifted the inquiry from just an individual conduct into questioning the whole institution instead.
And then just staying with that central focus on the Section 27 referral, why do you believe, Dr. Maganoe, you had this very highly experienced advocate struggling to define or to explain a fundamental legal concept such as Section 27 and that Section 27 referral affidavit to Justice Mbuyiseli Madlanga and the Commission at large?
The Commission was testing the standard of leadership that is expected from the head of an anti-corruption institution, right? I don't think they were necessarily looking at whether she had the experience or whether she understood the law. I think they understand that she does. I think she has over 30 years experience. So I think throughout her testimony, there were repeated references to her experience, not because the commissioners doubted that she understood the law, but because they were asking whether someone with that level of expertise would appreciate the legal implications of decisions that she was making or the decisions that were being made under her as the head of that institution. So I think, in other words, the issue was not really about her legal knowledge, but more about accountability for the exercise of public power.
And of course, the Commission also questioning whether IDAC had in fact applied the correct legal test, especially with regard to this complaint that was referred to IDAC via the Office of the Police Minister, Senzo Mchunu, through his Chief of Staff, Regine Kabinde, and how IDAC actually went about triggering their jurisdiction in this entire matter. What did you make of all of that?
That was a very interesting part of the testimony yesterday, because I think the reason why the commissioners kept probing into that Section 27 referral was the difficulty that lay in how Advocate Johnson gave us the chronology of the events, right? So the minister did not the minister's letter itself did not engage IDAC's statutory mandate. Remember, Section 27 is the one that triggers jurisdiction for IDAC. So that letter from the minister, it didn't engage IDAC's statutory mandate, and Advocate Johnson also accepted that when the commissioners were asking how that Section 27 affidavit came about. So the Section 27 affidavit only emerged afterwards. So the commission asked whether IDAC approached Mr. Adams to obtain an affidavit that would basically provide the legal basis for an investigation that had basically effectively already begun. So Advocate Johnson accepted that the investigator acting under her authority contacted Adams but maintained that there was nothing improper about that conduct. So the commission, however, was testing whether the sequence or that chronology reflects the ordinary receipt of a complaint or whether it suggests that jurisdictional function was created after the fact to give IDAC jurisdiction.
And of course, quite a bit of time spent on that particular matter of IDAC actually obtaining that Section 27 referral from Adams. And again, also looking at what was contained in whatever was referred to IDAC and what they then ultimately, Dr. Maganoe, ended up investigating. That was very interesting.
Yes, because if you remember from the testimony, they asked that, or the commissioners asked why it seemed as if though Mr. Adams' affidavit included more information than somebody or a layperson would know in order to trigger that investigation. So if a complaint is genuinely made by a member of the public, that's entirely consistent with a statutory framework, right? The concern here was that it's a bit different because the investigating authority itself may have influenced the content of that complaint that later became a basis of its own investigation. So it seemed, I think the question that the commission is basically asking right now is whether IDAC created its own jurisdiction and then formulated its own investigation in order to investigate everybody else who was implicated in that Section 27 affidavit.
So, do you believe that Johnson successfully distanced IDAC from allegations that it is conducting political turf wars, given what was testified to yesterday and given the questioning by the commission and at points her inability to properly explain why they ended up investigating General Khumalo and others? Do you think that, she did enough to allay some of the fears that they may be involved in turf wars as IDAC?
I think that's a tricky one, right? Because I think the broader question now is it's more of a constitutional issue. Because remember, IDAC was established from the Zondo Commission or the State Capture Commission to strengthen South Africa's response to high-level corruption. So its legitimacy not only depends on investigating corruption, but also in demonstrating that its exercise of public power is lawful, transparent, and independent. So if we have the head of that institution now being questioned about the manner in which certain investigations were conducted, it casts a cloud over not only the Advocate Johnson herself, but also the institution itself. Whether she was able to distance IDAC from those kind of allegations or not, I don't think so, because if you think IDAC, you think the head of IDAC. So yes, it may not necessarily be about the institution itself. It's mostly a constitutional issue when it comes to accountability. But whether she was able to distance IDAC from all of these allegations, I'm not quite sure about that, because she is the head of IDAC. So basically, she is also the face of that institution.
And if we just take it back a few steps, Dr. Maganoe, again, looking at that affidavit, and what was contained in the dockets. She was quizzed about this over and over again in terms of what was contained amounted to suspicions at best. And how you move then from Adams's complaint about his dockets going missing and his dockets not being, worked on or investigated to now looking into an HR issue that involves a former employee of BMW in Brigadier Mokwele, and then also into General Dumisani Khumalo and Mashaba and others. How do you go from that complaint and you land somewhere where you end up charging the whole head of crime intelligence? That was something that was also a bit shaky. How did you see that?
Indeed. And I think maybe because we are also speculating here because she didn't give us all the evidence through her testimony. I think what we need to take from that also is that investigators are not confined to specific names appearing in that initial complaint, right? So the issues that Advocate Johnson repeatedly, the issue was that she was repeatedly asked to explain where those additional names came from and basically give evidence that justified the inclusion of those names, right? So I think she wasn't able to clearly identify the evidential pathway. That is why the commissioners kept asking her the same questions over and over and over. That doesn't prove that the investigations were unlawful, but it does raise legitimate questions about whether each investigative step was rationally connected to the evidence, which is a constitutional requirement whenever public power is exercised. So she wasn't able to give us, or she wasn't able to give the commission a legitimate justification or a legitimate reason as to how everybody's name ended up in that process. And that is exactly why the commissioners kept asking her the same questions over and over and over, because she wasn't able to justify that. I'm not sure what's going to happen today, but hopefully she will be able to give us the correct sequence that basically led to everything that transpired with those investigations.
And you mentioned the chronology earlier, and that becomes important. Even if you just look at the timeline of Adams's complaints, you know, from the first complaint and how it moved from Cape Town to Gauteng and to triggering IDAC's their involvement in that whole investigation. That seemed rather quick by South African standards. I'm not sure what you made of that, because as lay people, we know it takes forever for the South African Police Service, in most cases, to get going.
So if you look at yesterday's questioning, it repeatedly focused on whether there was a proper legal and evidential basis for initiating those investigations, right? So the commissioners were probing whether the Section 27 process was used as as Parliament intended, because remember, this is legislation and Parliament makes the legislation, right? So they were trying to establish whether that Section 27 was used the way Parliament had intended, or whether the affidavit genuinely initiated that investigation, and whether the subsequent expansion of the investigation was supported by evidence. So those are serious questions, but I think at the end of the day, they remain questions because they are not findings yet. The commission is still trying to find the facts, because remember, the commission is a fact-finding process. So they haven't reached a conclusion, or they haven't made findings. But that Section 27 and that affidavit are basically going to be, I think, another focal point today, because in order for the commission to make the findings on whether the correct steps were used when public power was exercised, they need to probe further into how those investigations came about.
And of course, you know, there was a scathing lesson in there as well for Advocate Andrea Johnson with Justice Madlanga, not holding back. To quote what he said, even a law student doing their first year would know that. How could you mix the subjective test and objective test? Completely escapes me, is what Justice Madlanga said to Advocate Johnson, you know, as she was being criticized for applying the wrong legal test when she was considering that Adams complaint and its compliance with the NPA Act. Again, credibility. It speaks to the credibility and how we as layfolk then view IDAC.
Exactly. So that was, I think, my favorite part of the testimony yesterday. I don't think that Justice Madlanga was basically saying she didn't understand The test, I think he was basically saying, I know that you understand the test, but because you're not able to justify why you made certain decisions, it seems as though it was an oversight on her part.
And there were quite a few times when she sort of made that sort of concession. And I was saying, and this is, of course, purely subjective in this instance. This is my view on this particular matter, Dr. Maganoe, where I don't think Advocate Andrea Johnson didn't understand what she was doing. And I was just wondering, is she, at this point, by admitting and conceding to some of these points from the commissioners, is she rather choosing to accept certain of these concessions and say, well, I'd rather say I didn't know, as opposed to admitting that perhaps I did something that may be more nefarious in nature?
Exactly. So if you look at the pattern that most of the witnesses do, or what they do when it comes to giving evidence at the commission, what they normally do is, if somebody says, I don't remember, or I'm not sure, it's because they're trying not to perjure themselves, because remember, perjury is a criminal offense. So it's easier to say you don't remember, or it was maybe oversight, so that you don't implicate yourself in that sense. Because remember, on the first day of her appearance, she invoked her Section 35 that she will not incriminate herself because she's already under a criminal investigation. So it's easier in certain instances to say you don't remember or you don't know, because then you are not perjuring yourself, because intention is a much higher threshold to prove when it comes to perjury. If we can't necessarily prove that you had the intention to mislead, then we can't charge you, or you cannot be charged or found guilty of perjury. So if it's not necessarily that they are denying or that they are lying in that sense, or they're being untruthful, but it's definitely easier to say you don't remember, because then he who alleges must prove. So if the commission is of the view that you are being untruthful, they would also have to prove intention, that you basically intentionally misled the commission. So it's easier to say you don't remember.
And of course, I know you don't have one, but I'm going to ask you to just quickly peer into your crystal ball and looking at what happened yesterday. What can we expect today? Also taking into account the fact that the commission adjourned earlier than usual because Advocate Johnson was apparently not feeling too well or feeling the effects of her medication. Let's just speculate. If she were to not appear today, should we read anything into that, or should we just leave it as it is, that she was not feeling well?
I think we should leave it as she was not feeling well, and hopefully she will come back and clarify all the questions that the commission has.
Well, it's going to be another interesting day, and no doubt you and I, Dr. Maganoe, among others, will be watching. And I must just say, I generally tend to watch the commission on the SABC's YouTube channel, and yesterday, 30,000 people at around 10 a.m. was sitting and watching the commission, and you'd imagine these are people who are at work, but it just goes to show the interest that South Africans have in the Madlanga Commission. But thank you so much, Dr. Shadi Maganoe, who is a senior lecturer at the Wits School of Law, giving us some analysis regarding Advocate Andrea Johnson's testimony at the Madlanga Commission yesterday, expected to continue today.